Hi, today our group will present case study about Choy and others against Landyork, Farmings, Neighborhood and others 2019 Malaysian Law Journal unreported 1049. My name is NURUL. The FAIES will convey intro of the case, background of the case and fact of the case. For introduction, on the case of Choy and others against Landyork, Farmings, Neighborhood and others 2019 Malaysian Law Journal unreported 1049. Background of the case. The first plaintiff was Chow Kun Heng. Another plaintiff did not state his name in this judgment. The 9 defendants, the 6 defendants was Ng Hong Chen. Other defendants did not state their names in this judgment either. The case is under civil summons JA24 and SITI 1207/2018 and was tried in Johor Bahru High Court with the judgment delivering the judgment. Overall merit Peters judgeship. The date of the case was decided 15 September 2019. For fact of the case, the plaintiffs in this case were minority shareholders. The first plaintiff was a director of the first defendant company. The second, third defendants were the shareholders of the first defendant company, while fourth, fifth, sixth, seventh, eighth defendants were the directors of the first defendant company. The sixth, eighth defendants were also the directors and shareholders of the second defendant companies. The alleged wrongdoings occurs. The first and second plaintiffs claimed they had transferred RM 342484 into the first defendant's company, and the defendants refused to issue the share certificates to them. B. Following the power of the major shareholders, the defendant deleted the first and second plaintiff's share, which was worth 600,000 shares to the second defendant's company. C. The defendants denied the right for the plaintiff to access all the vital documents of the first defendant company. The oil palm plantation's payment was improper as the plaintiff's told sum of money was contributed in cultivating oil palm on lot 6988. Unlawful transactions were made by UFresh Neighborhood lot 703. Purportedly theirs was failed to redeem and it was subject to the bank's charge to run the first defendant company. And lastly, the first defendant ran their company by using RM 750,000 ringgit, which they presumed owing the plaintiffs the said amount. So next we move to following the matters conducted by defendants. The plaintiffs sought some relief for being affected parties. Like A, they asked for declarations to not discriminate and prejudice by the majority shareholders, directors and company secretary against minority shareholders. And B, the plaintiffs also request for appointing a professional accountant to look through the vital documents, the accounts, if there was any suspicious transaction. C, the permission to release from the personal loan and to retrieve the lot 703 from the charge of the bank and issue document of title is also in the list of the plaintiffs in order to retrieve their rights back after they failed to redeem it and became Pertanian Daya Teguh Berhad to run their company. D, the balance of RM 21694 38 cents was claimed to return to the plaintiffs as the share surplus were never allocated to the group. And lastly, the first defendant ran their company by using RM 750,000 ringgit, which they presumed owing the plaintiffs this amount, but the truth is, he failed to pay them. The plaintiffs issued for their RM 750,000 to be returned back. Regarding to this payment and relief sought above, Johor Bahru High Court laid down Section 346, 347 and 348 of the Companies Act 2016. The whole section was applied in this case since there were discrimination towards another in the company that resulted them to losses of hundreds ringgit. court referred to Owen Sim Yang Hui against Piazza Jais Berhad and another 1996 for Civil Law Journal 716. The question arises by the court whether there is oppression, intolerance, or discrimination. By looking through the past cases and laws provision, the court denied the relief since it was one with allegations and relief sought for the plaintiff's benefit in a mala fide way and unjustified evidence. The court decided to dismiss the plaintiff's claims and allegations on discrimination against minority shareholders with the cost Rm 12,000 ringgit.
Okay, now I will explain about the decision of the court in this case. A court decision on the right and liabilities of a party in action or legal proceeding is known as a judgment. In most cases, the judgment also includes the court rationale for why it made a particular court order. There are found 7 judgments in this case based on the fact that found in this case. Judgment number 1. The court held that it is improper for the first defendant to issue a certificate of share to plaintiff when they did not make the share their subscription. Plaintiff claim of minority suppression for the loan of a personal nature from the first and second plaintiff to the first defendant are unfair and misplaced. Judgment number 2. The court ruled that the plaintiff were not entitled to say that the first defendant had malicious intent to misuse their dwindling shares. Plaintiffs were found not to subscribe for a new share due to lack of their share, and this showed it was unfair for them to have an awful suspicion of intention. Judgment number 3. A director in a company has the right to full access to the book of accounts or the accounts and all company documents. The allegation that the first defendant acted as an operation against the minority shareholder or the first plaintiff was inconclusive and there was insufficient evidence. Judgment number 4. The court held that the allegation made by the first plaintiff against the defendant did not have any effect on him. This is because the decision taken by the defendant company are part of its own internal management. In addition, the plaintiff claims was not accepted because it did not meet the requirement of Section 346 of the Company Act. Judgment number 5. Complaint about the first defendant company offering credit coordination to Ufresh was not an issue because it was part of its business and was an internal management issue. Plaintiff may disagree with the defendant management decision, but this does not support a judgment of minority operation. Judgment number 6. The court finds that the defendant failure to redeem Lot 703 in violation of Clause 99.9.2. The agreement between the first and second plaintiff with the second defendant has nothing to do with the operation of minority shareholder, which is the principal point on which the application is based. Judgment number 7. The court held that there was no reason for the defendant to pay 750,000 to the first plaintiff. This is because the Pertanian Daya Teguh Sdn Bhd share sale agreement and trust deed revealed that the shares sold by the first defendant were unreleased to the payment for the plaintiff. And as a conclusion, the court finds that the application is only for the benefit of the first and second plaintiff, acting in their sale capacity rather than as a stockholder. The court questioned the plaintiff's honesty in pursuing the minority operation claim. As a result, the plaintiff claim of minority shareholder operation is dismissed with the cost 12,000 ringgit. That's all from me.
Okay, moving on to the ratio decidendi. The word ratio decidendi is defined as the reason behind the judgment made by the judge. It comprises all the legal principle or points that the court mentioned following his decision. The ratio decidendi establishes a precedent, which is the legal principle applied by the judge or judges in resolving the legal issues presented by the circumstances of the case. Following are the legal principles that the court mentioned in this case. According to Section 346 of the Companies Act 2016, An act of operation shall be invoked only when there is any conduct that relates to the section. It is also highlighted in the case of Ri Kong Tai Sawmill, Sendirian Berhad. As a minority shareholder, one should follow or accept any majority rule adopted by the majority shareholder unless it relates to the act under section 346. It is mentioned that the sole fact that one or more of the company's executive have a majority of the voting power and use their authority to make policy or executive choices that the complainant does not agree with is insufficient. On the basis of principle, in the case of Re 5-minute car wash in 1966, the fact that a member of a company has lost confidence in the way the company affairs are conducted does not imply that he is oppressed, nor can resentment at being outvoted, nor can simple dissatisfaction with or disapproval of the company's affairs, whether on policy or efficiency ground, however well founded. Furthermore, in the case of Kwa Jui Hyong and others and Kita Sang in another appeal in 2014, a complaint made regarding the operation of minority shareholders shall only be referred to the conduct that is personal wrong to the minority shareholder and not relates to the distinct corporate wrong. Moreover, the relief that is sought in regard to the operation must be referred to the issue of misconduct and shall not be related to mismanagement. Lastly, in the case of Datuk Teng Chet Si and Datuk Haji Muhammad Tufail bin Mahmud and another in 2007, it is stated that the application made under the section 346 should only be referred to the situation where the act of operation affects the petitioning member or co-member. If the court discovers that the applicant is seeking an order for a collateral purpose, the application will be dismissed as an abuse of the court process. He is referring to the case of Belado Silk Limited in 1965. That's all from me.
Now, let's see to the our analysis based on this case, which is our legal opinion. We discover that the issue in this case is whether there is oppression by the directors to the minority shareholders' interests. The minority shareholders may file an application for remedy or relief or protection if their rights and interests are disregarded by the directors' company under Section 346 of the Companies Act. We agree with the court that the claims by the plaintiffs were incorrect, as there is no unfairly discriminate to their interests, and not every application or claim can be considered as an act of operation to the interests of the minority shareholders. The plaintiff in this case, or the minority shareholders, must able to identify when their interests and rights are being violated by the directors. Secondly, the plaintiffs also must differentiate between the personal wrong or misconduct or mismanagement by the company. If there is operation, the aggrieved parties, which is the minority shareholders, must prove they suffered sufficient loss to their interests. That's all from us. Thank you.